So when you are talking about what is Article 21 capital A, it is a fundamental right. What is the age group?
6 to 14.
14 years. And when you are talking about Article 45,
Below 6 years.
so 6 years. And when you are talking about Article 51, capital A, K,
6 to 14 years.
6 to 14 years, that is fundamental duties.
Duties.
This table is very very important. तो कौन से
सर ये सर ये फर्स्ट और थर्ड वाला तो सेम है, ये अलग अलग करने की इनको क्या जरूरत थी?
जस्टिसएबिलिटी फैक्टर पढ़े नहीं पढ़े? विच पार्ट इज
हाँ, गॉट इट,
जस्टिसेबल
गॉट
एंड
इट।
विच पार्ट इज नॉट जस्टिसेबल?
फंडामेंटल राइट आर
are
जस्टिशिएबल,
justiciable
डीपीएसपी एंड फंडामेंटल ड्यूटीज आर नॉट जस्टिशिएबल.
and preamble also.
Preamble also, very good.
You have this Article 21 capital A.
सर रुकिए, टेबल बना लें.
Over
हो गया सर.
Okay, done. What is Article 22?
Protection in case of protection against arrest and detention in certain cases.
So Article 22 states that. Please read Article 22.
Article 22 states that the person shall be informed of the grounds of his arrest. He shall have legal practitioner of his choice, and he must be produced before the nearest magistrate within the 24 hours of his arrest.
So what is Article 22 states that person shall be informed of the grounds of his arrest. These are the basic rights. These are the basic rights. The person shall be informed of the grounds of his arrest. He shall have legal practitioner of his choice, and he must be produced before the nearest magistrate within 24 of his arrest, excluding
Time.
Traveling time.
Travel.
excluding the traveling time. So what are the rights under Article 22 a person will get?
Grounds of his arrest, have legal practitioner of his choice,
Within 24 of his arrest, excluding the
near magistrate traveling time.
traveling time. So what the Article 22 says? Very, very important. Person shall be informed of the grounds of his arrest. Second, he shall have legal practitioner of his choice. And third,
Produced before the nearest magistrate within 24 hours of his arrest.
excluding the traveling
traveling time.
time.
Sir,
Sorry,
Article 22 says that arrest and detention of certain cases.
इतना याद रखो काफी है. That's all. I'm not going into the constitution now. मैं जो important है वही दे रहा हूँ बस,
Okay.
जो एग्जाम के हिसाब से है.
Okay.
नेक्स्ट, ये 3 चीजें याद रखना.
Hmm.
In case of preventive detention, arrested person can be put in jail for कितना?
3 months.
For 3 months. प्रिवेंटिव डिटेंशन में कितने दिन तक रख सकते हैं जेल में?
3 months.
फॉर 3 months. इतना याद रखो. क्लियर?
Sir, in judicial detention,
So in preventive detention, arrested person can be put in jail for 3 months.
3 months.
Generally, what are the rights a person will get if he is arrested? What is the first right?
Grounds of his arrest.
Grounds of his arrest. He shall have legal practitioner of his choice produced before the nearest magistrate within 24 hours of his arrest, including the traveling time. अगर प्रिवेंटिव डिटेंशन है तो कितने महीने रख सकते हैं?
Arrest excluding the
If it is preventive detention, how many months?
3
3 months. इतना याद रखो, it's more than enough for your exam. Next, what is Article 23?
Okay, sir. Prohibition traffic in human beings and forced labor.
Slow.
Prohibit traffic in human beings and forced labor.
Prohibits traffic in human beings and forced labor.
Forced labor.
So what is Article 23?
Prohibit traffic in human beings and forced labor.
इतना याद रखो, काफी है. Article 23 prohibits traffic in human beings and forced labor. What Article 24?
Prohibit employing children below age of 14 in any hazardous employment.
So Article 24 talks about prohibits employing children
Employing
below
age of 14.
Below the age of 14 years in any hazardous
employment.
employment. Hazardous means dangerous. So in your table, you can just add one more. Article 24
24.
below
14 years.
14 years, and it is fundamental rights.
Right.
What is Article 24?
Prohibit employing children below the age of 14 years in any hazardous employment.
Hazardous employment. Next. What is Article
Article
25?
25. Provides freedom of conscience and free profession, practice and propagation of religion subject to public order, morality and health.
subject to public order,
public order,
morality, and health.
and health.
So, Article 25, freedom of conscience, free profession, practice, and propagation of religion.
Religion,
And what are the restrictions, grounds of restrictions on the Article 25?
public order, morality, and health.
Public order, morality, and health. Note, Article 25 does not include right to force conversions.
Hmm.
Very, very important. Article 25 does not in what does not it does not include
Forced conversion,
force conversions. Article 25 does not include force conversions. So what is Article 25?
Article 25 does not include right to forced conversion.
For Article 25, freedom of conscience, freedom, free profession, practice, and propagation of your religion, but are subjected to public order,
Public order,
morality, and
morality, and health.
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 And it does not include
Forced conversion.
forced conversions. Next, what does Article 26 says?
Provide freedom to manage religious affairs. This guarantee is available not only to citizens of India but to all persons, including aliens.
तो क्या है? Article 26 provides freedom to manage religious affairs, not only to Indians, but also aliens who are non-citizens.
Aliens.
Article 26, freedom to manage religious affairs, available to both citizens as well as aliens.
Non-citizens.
What is Article 27?
Give freedom as to payment of tax for promotion of any particular religion.
So freedom as to payment of taxes for the promotion of particular religion. What is Article 28?
Prohibits religious instruction or any worship in educational institutions maintained by the state.
Prohibits religious instructions of any worship in education institution maintained by
educational
state, माने government. What is Article 29?
States that the citizens having a distinct language, script, or culture shall have the right to conserve the same, and no citizen will be denied admission into any educational institution maintained by the state on the grounds of religious, race, caste, language, etc.
So what is Article 29 says? Citizens having distinct, माने एकदम उन लोगों के they have their own what are language, script, and culture.
Culture.
They will have the right to conserve, that is protect. They will have the right to conserve or protect, and no citizen shall be denied admission into any educational institution maintained by state
State.
based on the grounds of
religion, race, caste, language.
Religion, race, caste, language, etc. Okay. What are the three things you have to remember in Article 29?
Language, script or culture.
Language, script, or culture.
Culture.
And there can be no discrimination based on
Religion, race, caste, language, etc.
religion, race, caste, language, etc. Okay. Next. What is Article
Article
30?
30 gives right to minorities to establish and administer educational institutions.
That is religious and linguistic rights. Article 30, right to minorities.
Minority,
What are the minorities?
religious and linguistic minority.
Religious and linguistic minorities based on language. Very, very important. What are the two minorities in the
Religious and linguistic minority.
religious and linguistic minorities? Article 29 में
Yeah.
क्या है? Language, script और culture. और Article 30, religious and
Religious and linguistic
linguistic
minority.
minorities. Next. Article 31,
Which provides for right to property, which was repealed by 44th Constitutional Amendment in 1978. Now it is not a fundamental right, it is a legal right protected under Section 300 capital A of the Constitution of India.
so we have already learned this. It is a legal right now,
Legal
protected
right.
under section,
300 capital A.
protected under article, not section. Protected under article
300
300
capital
capital A of the Constitution of India.
A, India. In the presence of Morarji Desai,
Prime Minister.
Prime.
Okay. Any doubts still here?
No.
So Article 31 is not important. Then Article 32. Read Article 32.
Give right to every individual to move the Supreme Court directly in the case of violation of his fundamental rights through of the five one of the five writs, i.e., habeas corpus, mandamus, certiorari, quo warranto, and prohibition. The third is prohibition.
That is habeas corpus, mandamus,
Habeas corpus, mandamus, prohibitions, quo warranto, certiorari.
so what are the five writs?
Habeas corpus, mandamus, prohibitions, quo warranto, and certiorari.
Habeas corpus का मतलब
Have the body
have the
to end
body.
illegal detention.
What is mandamus?
To command,
What is prohibition?
to stop,
What is quo warranto?
by which authority,
By what authority? What is
authority,
certiorari?
to certify,
To certify.
certify.
So these are the very, very important five writs Article 32. What is Article 32? Gives right to every individual to go to Supreme Court directly
Directly.
in the violation of fundamental rights under the five writs. What are the five writs? Habeas corpus, mandamus, prohibition, and
Coherent and certiorari.
certiorari. Please remember, it's very, very important. Any doubts still
Constitutional
here?
remedy. Sir, Article 32 is for constitutional remedy.
Constitutional remedies which होते हैं और
Sir, Article 32 is a mini constitution. Sorry, Article 34 amendment.
here are the five writs. Five writs को क्या बोलेंगे आप? They are called as constitutional remedies. It is
Remedy.
heart and soul of the Constitution.
Constitution.
Who said it?
Dr. B.R. Ambedkar.
By Dr. B.R.
Ambedkar.
So what are the five writs you have? Habeas corpus, mandamus, prohibition, covenant, and certiorari.
Certiorari.
Okay, done.
Yes.
Okay. Any doubts still here?
No, sir.
So we'll go for limitations on the enforcement of fundamental rights. Now please read.
Limitation on the enforcement of fundamental rights.
So
The Parliament has
just
the
इतना
power
याद
to
रखो.
modify.
Not all is not important. What is Article 34?
Martial law enforced in any part of
Martial
the
law.
martial law.
Article 34 talks about
Martial law.
martial law. What is Article 35?
Parliament to make laws.
Parliament to make laws to give effect to the provisions of Part 3. Next point.
Article 358.
क्या है? Fundamental rights are
Not absolute rights. The Constitution provides for the suspension of fundamental rights under exceptional circumstances.
not absolute rights. The Constitution provides for the suspension of fundamental rights under exceptional circumstances. What is Article 358?
Provides that when the
Proclamation of emergency is made under Article 352.
352.
नेक्स्ट।
The freedoms guaranteed by Article 19 are automatically suspended and would continue to be so far for the period of emergency.
तो आर्टिकल 19 क्या है, ऑटोमेटिकली सस्पेंड हो जाता। आर्टिकल 19 इज ऑटोमेटिकली
Suspend,
सस्पेंडेड। और कब तक कंटिन्यू होता?
continue to be so far for the period of emergency.
फॉर द पीरियड ऑफ इमरजेंसी।
Emergency.
देन आर्टिकल 2021 ही पढ़िए।
Article 2021 cannot be suspended by any order under Article 359.
तो व्हाट इज रिटर्न? आर्टिकल 20 and 21 cannot be
Cannot be
suspended by any order under article 359.
359.
What are the two articles which cannot be suspended
20 and 21.
even if the emergency is imposed? Next.
Earlier, there was a controversy whether or not the Parliament has the power to amend the fundamental rights. This was settled by the Supreme Court in Keshavananda Bharati versus State of Kerala case 1973. The court held that it was compelled for Parliament to amend any part of the Constitution, including fundamental rights, except its basic structure. The same view was
The court held that court क्या बताया?
Keshavananda Bharati case.
So it was settled
Court held
by the
that it
Supreme
was
Court in the
compelled Keshavananda Bharati versus State of Kerala case. It was competent for Parliament to amend any part of the Constitution.
so what was held in Keshavananda Bharati case? कब आया केशवानंद
It
भारती
was
केस?
competent 1973.
1973. What was said that the court held that it was competent for the parliament, माने पार्लियामेंट लायक है अमेंड करने का एनी पार्ट ऑफ द कॉन्स्टिट्यूशन इंक्लूडिंग फंडामेंटल राइट्स, बट इट कैनॉट डिस्टर्ब द बेसिक
Basic
स्ट्रक्चर।
structure.
उसके बाद एक केस हुआ, उसका नाम है मिनर्वा मिल्स केस। कब आया मिनर्वा मिल्स केस?
1980.
1980। इसमें जो बेसिक स्ट्रक्चर क्या है, बेसिक स्ट्रक्चर में क्या क्या आता? So the Supreme Court said Article 14, 19, and 21 are part of basic structure and it cannot be amended. समझ में आ रहा?
Yes, sir.
What happened here? तो फिर से रीड करो एक बार।
Earlier, there was a controversy whether or not the Parliament has the power to amend the fundamental rights. This was settled by the Supreme Court in Keshavananda Bharati versus State of Kerala case in 1973. The court held that it was competent for Parliament to amend any part of the Constitution, including fundamental rights, except its basic structure.
And what is the next case?
The same view was reaffirmed in Minerva Mills case 1980, where the court also held that Articles 14, 19, and 21 are part of the basic structure and are hence
Amendable.
unamendable.
And hence unamendable. माने 14, 19 and 21 amend नहीं कर सकते. Clear a point?
Yes, sir.
और क्या आया था? It was also held that preamble is
Cannot the
part of the Constitution. Preamble is part of the
part of the
Constitution. In Keshavananda Bharati case. समझ में आ गया ये? Any doubts here?
No, sir.
Anyone? तो डाउट्स है इसमें?
No, sir.
Okay. Now take a break of 10 to 15 minutes. We'll start by 1:30. We'll detailedly read about the writs.
Okay.
Okay. Take a break of 15 minutes. We'll again start by 1:30.